This PowerPoint reviews concepts on visitation. It's our last unit and the one that calls for us to be the most active, dynamic, and strategic lawyers. As a starting point, let's look at the Uniform Marriage and Divorce Act. This tells us that a parent who doesn't get custody is entitled. That's strong. This PowerPoint reviews concepts on visitation. It's our last unit and the one that calls for us to be the most active, dynamic, and strategic lawyers. As a starting point, let's look at the Uniform Marriage and Divorce Act. This tells us that a parent who doesn't get custody is entitled. That's strong family law language, much stronger than we saw in custody, spousal support, or equitable distribution. Entitled to reasonable visitation rights. We're going to flag reasonable with a huge question mark about what that means. Entitled to visitation unless doing so would endanger seriously the child's physical, mental, moral, or emotional health. If we take a minute to reflect on this standard, we see jumping off the page our first unit on parental autonomy, and we see driving this an incredibly strong constitutional backdrop, suggesting that the parent who doesn't get custody nonetheless has a constitutional right to time with one's child. Some considerations to frame our unit. First, that question on what is reasonable. Reasonable is as squishy a word as we can get. Is one weekend a month enough? Is one day a week enough? That's the exact question we're going to wrestle with. Then we face the question of whether this is going to require a court order or whether this might be something that could be done negotiated privately among the parties. And we're going to practice negotiating in the context of our course. Regardless of whether you get there through an adversarial process and a court order or a private negotiation, nonetheless, the court will enter the visitation agreement through court in such a way that it will carry the weight of a contempt proceeding if a parent is in non-compliance. So the issue that we face is we need to find a way to craft a visitation order that is specific and detailed enough to be enforceable. Some jurisdictions will even tell us what the baseline is. That is a starting point. What does reasonable mean? Reasonable means every other weekend and one evening a week, alternating holidays and several weeks during the summer. This might be some of your own lived experiences as a child of divorce or as a party to a divorce. Notably, though, the modern terminology of visitation is a little bit outdated. What we're seeing is courts in very recent years moving toward language instead of parenting time. So we're still going to use visitation in our framing today, but nonetheless, in practice, we want to think about making sure that the non-custodial parent gets parenting time. Even if this unit's actually larger than that, because even if the parties were able to negotiate a joint custody arrangement, shared parenting time, we would still need an order to shape the logistics of what that parenting time would look like. So let's look at a couple of examples. This is just an example of a form that two parties with counsel or without might work to negotiate, to figure out what is the schedule. When does the weekend begin? What time does the weekend? What weekdays is the child with one parent? What weekdays is the child with the other parent? And you can see here just a framework to work through in a way that's going to be specific and detailed enough to be enforceable. Same goes for a holiday schedule. Are we going to treat holidays special? What even counts as a holiday? Do we want dad to have the children every Father's Day and mom to have the children every Mother's Day? This form is a method that parties might use to work through these specific questions. Same spring break. Do we just take turns? Does one parent always get spring break? Are we going to use odd and even? Does one parent get the children from Saturday to Wednesday and the other from Thursday to Sunday? These are all forms built out of years and years of practice and anticipating the kinds of ways that many families seek to divide their time. So it just gives us a preview for how specific and how detailed a well-negotiated visitation agreement or shared parenting time plan would be. This also looks at things like parent transportation and the exchanges of the children. Where are we doing this? Does dad bring the kids to dad's house? Does mom bring the kids to dad's house? How does this work exactly? And so we want to get all those details in place. What time, what location, what kind of transportation? Is there some sort of neutral party, a grandparent, for example, transporting the children? We would work all this out in advance to try to minimize conflict and to try to minimize the involvement of the court going forward. When we think about visitation, I want you to think about a huge web of discretion, and the very outer bound of that web sits constitutional considerations. So if we look back at the UMDA statute, it tells us as a model that generally speaking, the other parent is entitled to visitation. Why is that? Because it's coming from a constitutional right to raise or rear one's children. It is only going to be in the most severe and extreme of cases that we're going to see an all-out denial of visitation. Instead, what you're more likely to see are limits and restrictions on visitation. So if there are concerns regarding the children's health or well-being, the solution might be to have a third party with the children, to have visitation in public settings, to have visitations in court-structured and court-supervised settings. So the state is going to be very creative here in finding ways to get the children safe and productive time with the other parent. Why? Because it is their constitutional right. This is a very parent-friendly rule. And so we're not actually super concerned here. What we don't see in this test is the best interests of the children. We see parental rights driving heavily this constitutional right to visitation. The court is unlikely to order limitations based purely on things like the other spouse or the other parent having a relationship with another person, even though that might make the other parent profoundly uncomfortable. The court doesn't usually intervene there. It usually intervenes in these ways, focused more on the health and well-being of the children. Some special considerations just to think about that we don't really get time to touch on in this final unit. We will spend a little bit of time talking about contempt. In theory, a violation of a visitation agreement is no different than a violation of a child support order, but as a practical matter, we will study in this unit profound differences in the way courts handle child support versus visitation contempt. There are some really interesting special considerations when we think of military service and rules that allow parents to step right back into visitation as soon as they touch foot back on U.S. soil. And there are some very specific rules in each jurisdiction requiring parents to give notice before they relocate out of state. Because it's going to affect, even if they're a primary custodian with the ability to make decisions like that, because it's going to affect and impact the visiting parent, strong requirements requiring advance notice. One of the most interesting components, I think, of this unit is questions of standing. So grandparents, same-sex parents, same-sex couples, and step parents are the categories that most often come to mind. But here, interestingly, we're concerned about this because often courts give a presumption to a biological parent. But in our modern families, there are many individuals, grandparents, same-sex partners, and step-parents are the examples I provide here, who are playing parenting roles equal to or similar to a biological parent. And if a custody or visitation dispute emerges, that individual might not even have a legal right to come to court. So really focus carefully on that material. That's in our unit for this week, and thinking about how do these individuals even come to court to fight for their right for some sort of visitation with their children or grandchildren. Finally, one of the other things really interesting in this unit is to think about the standard of review. We are all sort of primed from TV and news to believe that everyone has a right to an appeal, and that if you get a bad outcome at the trial court level, no worries, we'll just take it up the ladder. But the key thing I want to emphasize here is that Questions of law are given the most robust review on appeal, often considered de novo, anew, by the appellate court. But the questions of discretion are really what we're talking about most often here. Is 1 week enough, 1 day enough, or do we need 2 weeks or 2 days? Those are discretionary decisions made by trial court judges. It would be a fact to say whether mom has an issue with alcoholism or whether she doesn't. That would be a question of fact, subject to a clearly erroneous challenge. And so there may be factual disputes too, but most often what's going to upset our clients on the losing end of a visitation dispute is the limited nature of the visitation or the supervisory nature of the visitation. And importantly, those types of decisions are subject to an abuse of discretion standard, which is a very heavily deferential view of an appellate court. So as we think about this, great lawyering matters, and great lawyering matters at the outset, because we're not going to be able to take this very easily up to an appellate court. So I hope you enjoy this final unit, and I hope as you practice in it, you start to see yourself come alive as a future family law lawyer.